Good evening. Today we will discuss CCS LEAVE Rules 1972. So first, subtitle. As you know, the title, the start of the first, the name of the particular rules, uh, so act or anything described. First, the title of the particular or particular act mentioned there. So, as you know, this was in effect from first day of June 1970. So, 1972 is very important here for terms of different rules of government of India. So, you might have seen CCS LEAVE Rules, CCS Pension Rules, Gratuity Rules. So, this year is important. So, respect to CCS LEAVE Rules, it was effective from 1st June 1972. Now, what is the scope of this CCS LEAVE Rules? So, we'll go to that scope and we will understand what is up to what extent this rule is CCS LEAVE Rules 1972 is applicable. So, as you can see, mainly CCS rules 1972 is applicable to government servants who are under civil service of Union, or you can say central government. Other organizations which are not covered under this CCS LEAVE rules are railway. So the government, the employee or employees who are working under railway are not covered under the CCS LEAVE rules. And persons in casual or daily rated or part-time employment. So even if some persons are working under, or you can say in the office of central government, but if they are in casual employment or daily rated employee or part-time employment, so this CCS LEAVE rules will not be applicable here. Next is persons paid from contingency. Sometimes what happens, some people are appointed for particular work or some kind of urgent work, and their payment is not made from, you can say, translated fund of India, or you can say grant of particular ministry. Instead, they are paid from contingencies. So they will also not be covered under this CCS LEAVE rules. Next is workmen employed in industrial establishment. Next is persons employed in work charge establishment. Member of All India Services. Persons locally recruited for service in diplomatic, consular and other Indian establishment in foreign country. So these employees who are covered under this 1-2G group, they have different set of rules or leave rules for them, but this CCS leave rules 1972 is not applicable. Next group, persons employed on contract except when the contract provides otherwise. So, if any person is on contract, that person will not be covered under CCS pension rule. But if that contract mention itself that the CCS leave rules will be applicable, then it will be applicable. Next is person in respect of whom a special provisions have been made by or under the provisions of Constitution or any other law for the time being in force. Person governed or for the purpose of leave by fundamental rules or the civil service regulation. And persons serving under the central government department on deputation from a state government or any other source for a limited duration. Sometimes if a state government employee is deputed for shorter period on deputation to central government or from any other source, they will not be covered under this CCS leave rules 1972. So there are some words, or you can say officials or different kind of specific authority which have been defined under this CCS leave rules 1972. So first is administrator. So as we know, administrator means any administrator or an administrator of duty. It's like uh, there are many union territory under the country. So the administrator of that duty is called uh, in different name in different duty, but here that official or that administrator will be called as administrator. So here administrator means the administrator of an a union territory. Next is audit officer. So audit officer means accounts and audit officer, whatever his official designation in circle, the office of the government servant is situated. Authority competent to grant leave. There is always an authority who has power to grant any kind of leave. So here authority competent to grant leave means the authority specified in column 3 of the first schedule of this rule, competent to grant the kind of leave specified in the corresponding entry in column 2 of the said schedule. So there are some schedules along with this CCS leave rules. You can see at the end of this schedule. So this is the schedule. This is first schedule. So what first schedule says? First schedule says the authority is competent to grant leave. So the question may be asked, what is mentioned under first schedule of CCS leave rules 1972? So under first schedule, the authorities competent to grant leave have been mentioned. So first kind of leave has been mentioned, and the competent authority has power to grant such kind of leave, like earned leave, HPL, committed leave, leave not due, extraordinary leave, maternity leave, hospital leave, semen's sick leave, paternity leave, child adoption leave. So these are all rule we will read as per this rule. So you can see who are competent authority to grant the leave. So first one is Ministry or Department of the Central Government. Second is Administrator. We will discuss. We have already discussed about Administrator. Controller and Auditor General and CAG. Head of Department. As you know, Head of Department is mentioned for every organization. And as you know, the minimum pay level of any head of department should not be lower than that of deputy secretary, that is level 12. So any other authority which is appointing authority, any subordinate authority to which authority at 1 to 5 may delegate the power subject to any condition that may be specified in the delegation. If the government servant is in foreign service, the authority which sanction the transfer of to foreign service. So here the authority competent to grant leave in foreign service would be the authority which sanction the transfer to foreign service. Foreign employer power to be exercised only in respect of earned leave not exceeding 120 days, and while taking decision to grant or refuse leave preparatory to retirement, prior concurrence of the lending authority under the central government shall be obtained as provided in sub-rule 2 of Rule 38. Here Rule 38 of CCS Leave Rules 1970. And next is, if the government servant is serving with a state government, the state government or such authority as may be specified by that government, while taking decision to grant or refuse leave preparatory to retirement, prior concurrence of lending authority under the central government shall be obtained. So if someone is on foreign service, then it must be uh, approved by the lending authority under the central government. In case the lending authority under the central government is not agreeable to the refusal of leave preparatory to retirement, it shall be granted to the government servant. If the state government needs the services of officer during that period, the government servant may be re-employed by that government concurrently with the leave preparatory to retirement, and leave salary regulated in accordance with the sub-rule 6 of Rule 20. Special disability leave. Here again, Ministry or Department of Central Government, Administrator, CAG, Head of Department, any other authority which is concurrent, which is the appointing authority. Study leave. Ministry again, a department, Administrator, CAG, Head of Department. Now, second schedule. Under second schedule, there are forms which have been prescribed under second schedule. So now we'll again go back, see the difference. Next is completed years of service or 1 year's continuous service means continuous service of specified duration under the central government and includes the period spent on duty as well as on leave including extraordinary leave. So if we discuss completed years of service or 1 year's continuous service, so this period of continuous service will include the period spent on duty as well as this includes leave also, and is under this leave this extraordinary leave is also. Date of retirement or date of his retirement in relation to a government servant means the afternoon of the last day of the month in which the government servant attains the age prescribed for retirement under the terms and conditions governing his services. So as you know, hence their date of retirement is what? Generally, it is the last day of month. If the date of birth of government servant is other than first day of that particular month. If the date of birth of particular government servant is first day of the month, then the government servant will retire on last working day or last day of previous month which he is going to attain the age of superannuation. Like if your date of birth is 2nd of February, then you can retire on 28th February or 29th February, either case may be. But if your date of birth is 1st February, then that government servant will retire on 31st January. Next, Department of Central Government means Ministry of a department of central government has notified time to time includes the Planning Commission, the Department of Parliamentary Affairs, the President's Secretariat, the Vice President's Secretariat, and Cabinet Secretariat, and the Prime Minister Secretariat. Next is disability. So, what is the disability? Disability means a specified disability, benchmark disability, and disability having high support needs as referred to the Rights of Persons with Disabilities Act 2016. So, as you know, disability has been defined under Rights of Persons with Disability Act 2016. And there are certain benchmarks, only then one can be declared as disabled person who are fit for job in or under central government. Next is foreign service. So as you know, foreign service means when you go, you here means government servant. Government servant goes to other organization while leaving the government, central government office where he used to receive the money from Consolidated Fund of India, or you can say Consolidated Fund of State, or Consolidated Fund of a Union Territory. So, foreign simple in simple terms we can discuss. Foreign service means a service where government servant receives his pay with the sanction of government. Of course, here the person would be receiving the pay with the sanction of government, because a government servant can go on foreign service only with the approval of or with the sanction of government. But here in foreign service, the source of his or her salary would not be Consolidated Fund of India or Consolidated Fund of the State, or you can say Consolidated Fund of UT. Next is form. Form means what? The form which are appended along with this CCS LEAVE Rules 1972. Actually, forms have been appended along with, or these forms are under Schedule 2 of CCS LEAVE Rules 1972, and you should remember that there are two schedules, first schedule and second schedule. So under first schedule, what we have discussed? Under first schedule, there are competent authorities who are empowered to grant leaves as per CCS LEAVE Rules, and whereas Schedule 2 contains different kind of forms related to. And next is quasi-permanent employee. Might have wondered many times what is government servant in quasi-permanent employee. This is very, you can say, a specific or peculiar kind of word. Where if you see, it is talking about an officer who, having been declared by UPSC to be eligible for appointment to the ministerial services of the Government of India, has been appointed to a temporary or officiating vacancy on the understanding given to him in writing before he took up the appointment that the vacancy is expected to become permanent but is not confirmed after completion of 3 years continuous service. Means actually if an officer declared is declared to be eligible for appointment of Civil Service of Government of India and has been appointed to temporary or officiating vacancy on the understanding that vacancy is going to become permanent, but it is not confirmed after completion of 3 years continuous service. So in that scenario, that person will be called as uh, government servant quasi permanent. Next is an officer who may be declared as quasi permanent under the CCS Temporary Service Rules 1960. So one category is related to uh, you can say a person who has been declared by UPSC to be eligible for appointment to the ministerial post or ministerial service under Government of India and has been appointed to a temporary or officiating. Remember here, initially they are appointed as temporary or officiating capacity or vacancy. While considering that the post may become permanent, but after even uh, completion of 3 years of continuous service, uh, they are not confirmed. So they would be given the status of quasi permanent employee. Next is government servant in permanent employee. So government servant in permanent employee means what? It means an officer who holds substantively or provisionally substantively a permanent post, or who holds a lien on permanent post, or who would have held a lien on permanent post had the lien not been suspended. So other than you can say you people who are under uh, different ministry or you can say working under different organization and who have been appointed against permanent vacancy, we call government servant in permanent employee. Where once you confirm, then you are on permanent payroll of government and you would hold a lien on your post, which you are holding substantively. Next is head of mission. So here head of mission means ambassador, charge d'affaires, minister, consul general, high commissioner or any other authority declared as such by central government, the country which the government servant undergoes course of study or training. Next is military officer means officer of armed forces who is a commissioned officer of army or navy or air force, or a junior commissioned officer including an honorary commissioned officer or an other rank of the army, or a branch list officer or rating of the navy, or an airman including a master warrant officer of the air force. So next is vacation department. So who will be covered or who will be called vacation? So vacation department means a department or part of department to which regular vacation are which regular vacations are allowed during which government servants serving in the department are permitted to be absent from duty. So, vacation department where regular vacation are allowed, and during this vacation period, government servants are permitted to be absent from duty. So, these department will be called vacation department. These are mainly related to educational institution. Next is words and expressions used herein and not defined but defined in the fundamental rules and supplementary rules shall have the meanings respectively assigned to them in the fundamental rules and supplementary. So there are some words or expression which has been used here but not defined, but it has been defined somewhere else like fundamental rules or supplementary rules shall have the meaning of respectively assigned to them in the fundamental rules. Means whatever definition has been given under fundamental rules or supplementary rules, the same meaning will be considered there. Now, government servant on temporary transfer on foreign service. Government servant to these rules apply shall continue to be governed by these rules under temporary transfer to the government, railways or state government or while on foreign service within. In the case of government servants on foreign service outside India, including service with UN agencies within or outside India, or on temporary transfer to armed forces of the Union, these rules shall apply only to the extent provided in the terms and conditions of foreign service or temporary transfer as the now transfer from services or posts governed by other leave rules. So you may know there might be some officials who are not actually appointed by central government, but they are transferred from other services which are governed under different sets of leave rules. So unless it be otherwise provided in these rules, permanent government servant, these rules down. Now, when transferred temporarily to a service or post to which these rules apply, shall remain subject to leave rules which were applicable to him before such transfer, and provided that where military officer not in permanent civil employee has elected to draw civil rates of pay, his leave shall be regulated as per the provision under this. So, if any military officer not in permanent civil employee has elected to draw civil rates of pay, then his pay or he will be governed under this. Provided further that in the event of his release or discharge from the armed forces, he shall carry forward the annual leave due to him with effect date of such release of discharge. Next is when appointed substantively to permanent post to which these rules apply, shall become subject to these rules from the date of such appointment, in which case the leave at his credit under the rules previously applicable shall be carried forward subject to the maximum limits of accumulation as determined in process. The leave so carried forward shall first be exhausted before the leave earned there under these rules is availed of. The leave salary in respect of leave carried forward shall be owned by the department of government which the government servant seeks out, provided that in case of military officer half the leave equal to the number of days of furlough shall also be carried forward in addition to the earned leave equal to the number of days of annual leave, the date he is so appointed. It would be permissible to grant him under the leave rules of the armed forces.